Good morning, everyone, and welcome to the South Carolina Department of Consumer Affairs webinar, the 2024 South Carolina Legislative Update. I am Carrie Gruby-Liebarker. I'm the administrator and consumer advocate at the department, and it's my pleasure to be here today to talk to y'all about this particular topic. So one of my roles as the administrator of the department is that I get to advise the legislature and the governor about topics, issues that affect consumers. And so we get to take our expertise in the regulatory of the non-depository credit environment over there and look at the complaint data that we see, the scam and identity theft information, all those services that we offer. We can pull that data and call that data together to provide information to the legislature and the governor so that they can make the best policy decision and have all the information that they need to be able to do so. So we get to follow the legislature. The legislature is divided into two parts, and they call them bodies. So it's the House of Representatives that's made up of 124 members, and then the Senate that's made up of 46 members. And together they form the General Assembly. So we have a legislative session in South Carolina that's a 2-year session. We just ended a 2-year session, the 2023 to 2024 legislative session. They come in each year on the second Tuesday in January, and then they end the second Thursday in May. They end the traditional session. They can do something called a sine die resolution that extends the session. Right now, we're in the middle of a sine die resolution that extends the session until November, but only for particular topics that normally include the budget, which was just put into place the first week of July. And then there could be other bills on that list of items that they're allowed to discuss, and including any law that had passed both bodies, but they just need to work out the differences. Those are often taken up during a sine die resolution. But traditionally, the session is that second Tuesday in January to the second Thursday in May. So we're going to talk about how a bill becomes a law or what that process is, but any member can make suggestions for new laws. They do have pre-filing of bills, and just because somebody introduces a bill in the House doesn't mean that somebody can't introduce a very similar bill in the Senate or vice versa, and we call those companion bills. And sometimes it's just the purpose is to try and get the bill going, right? You don't know where it's going to get traction, if it's going to get traction and movement on the House side or the Senate side. And so folks want to put all their chips in and get something moving, and they'll often do that via companion bills. But there is something called crossover. This is the second Thursday in April. And essentially, for a bill to become law without some extra steps or measures being taken, it needs to pass from the originating body over to the other body by that second Thursday in April for it to become law that particular session. So as an example, if we have a bill about making today, July 17th, National Ice Cream Day, then we find somebody in the House, a representative, to sponsor that bill, and they get it introduced. So we need that bill to pass through the House process and make it over to the Senate by the second Thursday in April in order for it to be able to be voted on and become law that particular session, that particular year. And again, there are some, different ways that if it doesn't pass crossover, that there can be a vote to get it on the floor, to get it, get it moving on that other side, but that usually does not happen. And then we always encourage folks to get involved. If you have a particular topic that you want to see a change in current law, or if you want to, you think there's a gap in law that you think should be addressed, your legislators are there to hear from you. I mean, like I said, it's our data that we often use to support policy recommendations to the General Assembly, but they want to hear from you. They want to hear from you, their constituents, on what's important to you. And if you have experience, if you are in a particular profession and there was a bill coming up that affects that profession, I mean, they want to hear about the boots on the ground folks too, and make sure that whatever they're drafting is not going to have unintended consequences, and to make sure they're thinking of all of the different ways that it's going to be implemented and how that'll affect the parties involved. So here's a little bit on what that process is for bills. So bills are read on the floor of the proper chamber. So that's wherever they're introduced, whether it's on the House side or on the Senate side. And then it's assigned to a committee to be studied. And usually that assignment is based on the title of the bill. Sometimes it's subject matter as well. So, and it could be the title that it's amending. So on the Senate side, because we have the Consumer Protection Code in Title 37, Senate Banking and Insurance has in their rules that Title 37 bills would go to banking and insurance generally. Again, there's always exceptions to the rule. And then the committee can take a look at it and they can accept, they can amend, or they could reject the bill. And sometimes it just stays in committee, like you don't ever see it get pulled out again during a particular session. And so if the committee does decide that they approve of the bill, or if they want to amend it, and then they send it back to the House floor where it gets a second reading and where that bill can be debated. And then there's a third reading as well, which there has to be a day in between, trying to give the opportunity for the members to make sure that they're seeing what's coming up on the calendar, and so they can be prepared for that. And then after it gets third reading, then it's signed by the clerk of that particular chamber and it's sent to the other body. And then it goes through a similar process on the other side. So whether it goes from the House to the Senate or the Senate to the House, they have a similar pathway for that bill. If both bodies like the bill and they want to pass it out, then they'll each have 3 readings on both sides. The clerks have signed it, and then it can be ratified. And then that's when it goes to the governor. And the governor has 5 days to sign the bill or it becomes law. Effective date is usually traditionally within the bill. The law provides that it would be the 20th day after approval by the governor, but usually it says within the bill that it's effective upon approval by the governor. And so this information just comes from a publication that's on the Statehouse website, South Carolina's legislative process, and the link is there. And again, we're going to be emailing out these slides so that y'all can visit that and get the full picture after our presentation. So how many bills became law last year? So we just again closed out a 2-year session. The 2023 to 2024 session was session 125 of the General Assembly. And there were 253 bills that passed. 244 of those were signed into law. 2 of them met the deadline, that 5-day deadline where the governor didn't sign it, and so they became effective anyway. The governor vetoed a bill that was then sustained by the legislature, and then he vetoed 4 other bills that were overridden, so they became law anyway. And then there are 2 vetoes that are currently pending and none that are awaiting the governor's signature. And so over to the right-hand side, this is a screenshot from the 2022 legislative manual. This also is on the Statehouse website, but it gives a rundown of sessions from 2003 through 2022, telling you the number of bills that were introduced, telling you the length of the session for how many days, and then how many acts were ratified. And so you can see the 253, it's about the same as we saw over the last couple of sessions, the 2021 to 2022 session and the 2019 and 2020 session. They're about over 200. So it looks like the 2023-2024 session had a little bit more than those last 2, but just look at the number of bills that were introduced. So you had in 2022, it was 1,268. In 2021, it was 2,661. I mean, I remember going into the 2023 first part of this session, I mean, there were over 1,000 bills, I believe, that were pre-filed, that were filed even before the first day of session. So I'm going to be curious to see what those totals are for this past session when they publish the updated manual. So again, all this information we're talking about can be found on the Statehouse website, scstatehouse.gov. And you can do quick searches for bills, all the bills that I'm talking about. You can search by bill number, you can search legislation for key terms, you can look at current laws in the Code of Laws, all sorts of search methods there. And then under the research tab as well is where you can get the information about how many bills were passed and what the governor did with those. And you could look at amendments that were introduced on certain bills. I mean, there's so much that you can do on this site if you want to dig into a particular topic. All right, I'm going to check to see if there are any questions before we move on to the pending bills portion of our presentation today. And just a reminder to put in your questions as they come up. Okay, so this is a great question to segue into the pending bills portion. So the pending bills that I'm going to talk about today, again, when we have over, thousands of bills that are introduced during a 2-year session, we at the department only follow those bills that affect the consumer credit marketplace or the consumer marketplace or subject matter that we deal with on a daily basis. So there's going to be plenty that we're not going to cover today. So if I don't, again, feel free to go to that statehouse.gov website, click the legislation button, and then put in a keyword to search through those. But one of the questions that we have is, what is the status of the bill to put some of the state agencies under one umbrella? So I'm going to guess that this is dealing with the health agencies. There were 7 or 9 state agencies that deal with mental health and corresponding subject matter that they were trying to put under one agency. And on the last day of session, the bill had met crossover, it had gone to both chambers, and there were amendments. And so it had ended on the Senate side with, I can't remember if they had, with some amendments, I do believe. So it came back to the House, and they had to have unanimous consent to bring the bill back up and essentially either accept the amendments or not accept them and say they wanted to go to conference committee. So they could appoint a conference committee and try and work out those differences. And that did not happen. And so essentially that bill is dead unless it got added or would get added to the sine die resolution that it could be discussed outside of the normal session. And I don't believe that that has happened. All right. So let's talk about other pending bills. And again, these are ones that are in subject matter areas that the department often follows or provides testimony on based on our expertise. So we're going to talk about pending bills in the area of lending, homeowners associations. Of course, you always have to have an other category, and then the energy reform bill. So first up for lending. So we have S910, and S910 would require an ability to repay analysis before a business gives a consumer loan or a payday loan to a consumer. It limits the number of renewals on a loan or the time frame between renewals of a loan, and prohibits live checks. Live checks are those checks that you would get in the mail that essentially say, if you sign here, it looks like a check, and it's like, but it gives the disclaimers and the disclosures that if you sign there, it would be a loan, and you would have to pay X APR. That all has to be disclosed on there. So essentially, it makes it an unfair trade practice if a business violates this particular bill. There were 4 subcommittee meetings on it. It was a very intensive review of it. Our office spoke, and then there was a representative from the Independent Financial Services Association who spoke. There was somebody from the American Financial Services Association who spoke, and then some folks who spoke from a group in the upstate that's looking out for the consumer interest in the area of loans. It came out of full committee in mid-February, but it was immediately contested. Once it got to the full committee level, there was lots of questions on it during the full committee, and then Senator Clymer, I think, was the one who had his name on it towards the end of session as well. So it really will likely come up, or something again will likely come up next session, because it did not go from one body to the other and get a conference committee appointed or anything. Then it died. So that's what happens at the end of a 2-year session. If a bill does not make it to the sine die resolution, then it's dead, and you got to start all over in the coming session. So somebody would have to refile the bill. And this particular bill was introduced very early on in the 2024 half of the session, and it kind of came on the heels of a bill that had been introduced in the 2023 part of the session, which was S518, and this limited the APR of deferred presentment, which is payday loans, supervised loans, which is those that are 18% and above, supervised financial organizations, which could be also considered banks, supervised financial organizations, and then consumer finance companies. So it was just a blanket 36% all in APR. There was lots of movement in 2023. They had a lot of meetings on it. Lots of folks testified from the different interested party groups, but there was no movement on it in 2024. Again, the kind of interest shifted over to the S910 bill. And there are a couple other bills that have 36% rate caps that were hanging out there, but they were dealing with payday lending only. And then there are caps on interest rates for title loans under a separate bill, S54, that created kind of a tiered structure, which is something we saw in the early 80s, late 70s with consumer loans, but there were no meetings on that particular bill. So again, because these bills did not cross over from one body to another, you got to restart, cannot pass go, got to go back to the beginning and reintroduce those if somebody is interested in them. Now I'm going to talk about homeowner association bills. There were 8 of them that I'll say at least 8 homeowner association bills that were introduced during the 2023-2024 legislative session. The current law sets out some requirements for homeowners associations, including the filing of governing documents, rules and regulations with the county, giving a homeowner access to rules and regs and amendments. There's access to annual budget and membership lists. There's other certain notice and disclosure requirements. A magistrate is allowed to hear certain monetary disputes. And then it requires our office here at the Department of Consumer Affairs to take complaints that folks have related to homeowners associations and then give an annual report about the content of those complaints, a compilation, to the legislature, the public, and the governor every year. And so we followed this area closely. And H3180 is a bill that was introduced on the House side that essentially made it to where if somebody forecloses on a property, a primary residence, because of unpaid dues and fees of a homeowners association, they cannot sell it if the homeowner association is the one who initiated that action for that purpose. It is the only bill that we saw related to homeowners association that had lots of movement. It made its way through the House. It was sent over to the Senate April 10th, and then there was no movement on the Senate side for it. And just for information, other bills in the homeowner association area that was related to the budget or money, H3568, which would require the budget to be sent out to homeowners. They have to file it with our office here at the Department of Consumer Affairs, and had some notice and meeting requirements there. There was another bill, 3259, I should say, and that had similar budget requirements, but it was really only dealing with sending it out and to our office. Then S118 would require a homeowner association to provide a statement of unpaid assessments and other charges to a unit owner upon the request, and it has to be done within 10 days of that request. Again, none of these may cross over, so they would have to start all over again in the 2025-2026 legislative session, which is crazy to say. There were some other bills that were introduced dealing with homeowner and tenant rights. 3258 about displaying political signs, S421 dealing with free speech and reasonable assembly, 3775 the permission to fly an SC flag on premises, which I think is already maybe in the law. I need to double check that. And then S422 dealing with solar panels, which is interesting. And it essentially says that nothing in that section would be construed to prohibit a homeowner association from requiring reasonable design accommodations. That's one of the things, people have different parameters within their homeowners associations for different items that you install, whether it's a fence or otherwise. And so this would not prohibit that kind of design accommodation being set by the homeowners association. So it just says you can't prohibit solar outright, essentially. But again, none of these bills even got a meeting, to my knowledge, and would have to be reintroduced next year if somebody wants them to become law. We did at our office, or we still are in actually, the House legislative oversight process. And as a part of that process, we were asked for legislative recommendations. Homeowner associations is one of our fastest growing areas for complaints. It goes under the real estate category, which is mainly made up of timeshare and homeowner association complaints. So we took a look through our data that we've collected over the last 5 years. We did a special homeowner association report in June of last year that contained data that we had received from June of 2018 through December 2022 for the homeowner association complaints, because May 2018, that law went into effect requiring us to take those complaints, and did a compilation report, went through that, and talked to the folks in our services division to come up with certain recommendations that we think could be helpful in this area at this time. And that included to require homeowners associations to have internal dispute processes detailed in their governing documents and communicating that to homeowners, permitting the magistrate's court not to just hear monetary disputes of a certain amount, but all homeowner association disputes, and then require the homeowner association to provide support to the department whenever there is a complaint that directly relates to the complaint. So like if somebody says the homeowner association is telling me that I can't fly the South Carolina state flag on my property because it says it in the rules and regs, then we would just want a copy from the homeowner association to show us, no, it says right here, this is what it is, because communication is often the main culprit in these homeowner association complaints. And so that's kind of the basis for a lot of our recommendations. That was just kind of some highlights there of what we submitted, and we'll see what happens next year. I was asked on both sides from members of the House and members of the Senate for information on homeowners association complaints, so I think there will definitely be some additional bills introduced next year. As far as the other category, this is an area that we get a lot of calls on. It goes through our voluntary mediation process because nobody has jurisdiction over it, but landlords and mold. And so we had two bills. So these were companion bills that required landlords to disclose if mold exists in a unit and to take reasonable steps to maintain a mold-free environment, remediate any mold that's found, and then requirements for a tenant to properly report mold. And then H3203 would require DHEC to create a standard for mold remediation companies. So those, I don't think either or any of those three got a meeting and did not move. And then we also had two bills that would make our office a cabinet agency. We currently have a commission that's 4 members are appointed by the governor, 4 by the General Assembly, and the Secretary of State serves ex officio. That's how it's been over the last 50 years. But there were 2 bills introduced to change that structure. But again, all of these did not pass over, or one passed over, but they didn't pass both chambers or get the conference committee level, so they must be reintroduced next year. We do have one bill that made it to the conference committee process before the end of the day on May 9th, which was the last day of official session, and that's the energy reform bill. So this is H5118, and it is a large bill. It was amended. It crossed over from the House to the Senate and was amended within committee on the Senate, or there were several amendments that were discussed. I don't believe that it made it to the floor, but there were, yeah, it made it to the floor and everything. I don't know that amendments, let's see. I'm gonna put up this slide real quick, and then we'll talk a little bit more about the content of it. But yes, the Senate definitely amended it, looking through it, but this is the history that the bill took. So it was introduced February 15th in the House, and then it went through their committee process and then back to the floor, read the second time at the end of March, and was sent over to the Senate and introduced and read the first time April 2nd and went through their process. There were amendments there, and it was sent back to the House, and the House said, nope, they don't concur. And so both sides decided that they wanted their own versions of the bill, and so they appointed conference committees that can meet until November under the sine die resolution. So what is covered under H5118? It's a whole lot. It's a pretty extensive bill that's trying to deal with energy reform. You may know that South Carolina was the fastest growing state as far as folks moving here last year, I do believe. And so what the legislators are trying to do, or what the goal is trying to make sure that the future of energy production in South Carolina is a stable one, and that the growth does not stifle the energy production and transmission service. You know, they still want to be able to provide safe and reliable service to all the folks that are moving in with that additional load on the system. And so there was discussion about a joint gas plant in the bill between Dominion and Santee Cooper. They're talking about coal retirement deadlines because coal is used in the production of energy. They're looking at the regulatory process for how utilities get approval for increase in rates and other products and services. And so they looked at the size of the Public Service Commission, which currently has 7 members. I think the House bill said it should be 3, and the Senate, I believe, amended it and said we'll go with 5. And then just the framework in all for how utility filings are handled. There's like changes in definitions, and there were some changes in what should be considered by the Public Service Commission during a hearing or during the filing process. It also removed the consumer advocate role, which we currently have here at the department, where we represent the interests of residential ratepayers in utility filings. So, you know, it's your water, your sewer, your electric, and your gas filings. Whenever companies are trying to increase those rates, we hire experts to say how that increase or how the filing would impact residential customers and make recommendations for what we think is fair and reasonable. It was a role that we had from 1978 until 2004, and it was carved out from our office when the Office of Regulatory Staff, another state agency who is truly the regulator of utilities, when they were created. But then after VC Summer in 2018, the role was given back to us, and so now there's discussion of taking that role from us again in this particular bill. I think the current language has it going into a separate standalone office within the Office of Regulatory Staff, but there's much more. I mean, this bill, it had certain findings, it had research groups that would be getting together. I mean, it really covers a whole lot, looking at just energy, the energy production in South Carolina. There were some areas of disagreement, again, between the House and the Senate, and so they appointed their conference committees. Conference committee has not met as of yet on this particular bill, but I think at the end of the session, and just looking at the legislative calendar, meetings are going to start ramping back up in August for some other, you know, just over at the Statehouse. So it could come up in the near future. So we'll be watching for that as well. And then just as a side note here, there was a bill dealing with energy production, and I guess essentially you can call it energy reform as well, that was introduced on the Senate side. It was S909. It was not a companion bill because they were not identical by any means. And so you can look at that to kind of see what the initial kind of, I guess, Senate perspective was too. So it was S909 on the Senate side. So that's the only pending bill that made it to the conference committee process. So that's the only one that is still alive at this point in time of the ones that we spoke of. Gonna see if we have any questions here before we move on. To the new laws. And just so you know too, and we'll talk about it towards the end of the presentation, but somebody asked about an app that the Statehouse has, and there is a legislative app that you can download onto your phone. You can follow bills through it, so you would get notification on your phone when bills are set for a meeting and when there's any action for or on that bill. And I'll show you where that sign up is on the main page of the Statehouse website when we get to the end of the session. And then somebody also asked about accessing the session. We're not recording the session to post it, I don't believe, but we'll at least have the PowerPoint that we will email out to all of the attendees. All right, so let's talk about some new laws. Again, there were 253 laws that are out there from these sessions. We are just going to be talking about the ones that our office either provided testimony on or we're following closely because it deals in our world, in the consumer world. And so that's narrowed down to 4: earned wage access, negative options, automatic renewals, online age verification, and an increase in pre-need funeral contract penalties. So first up, we've got S700, and that's the Earned Wage Access Bill. So this was introduced in March of 2023, and it inched on in there on the last day of session. It got concurrence and House amendments and was enrolled to get ratified. So what is earned wage access? It's providing access to a consumer's earned but unpaid income. And essentially, providers of this service must register with the department annually and submit an annual report. This is a newer kind of consumer product. Some states consider it a loan and some states do not, based on legislation that has passed. And so essentially the General Assembly said that they were going to pass this law, and a lot of members had the understanding that we would receive information through the annual reports here at the department and understand more fully how the product is being offered to consumers, and essentially go back in a couple years with an update to the legislation, or a proposal for an update to the legislation based on that data and that experience in regulating the industry and learning more about the industry. It requires certain consumer disclosures and notices in the process. It prohibits requiring a tip or other donation for the service, advancing more than the consumer's unpaid income. They cannot use a debt collector or a debt buyer, and there's plenty of other restrictions in there as well. So we have to come up with a new regulatory system more so that folks can actually complete the applications for registrations with our office. This is one of those bills that it was signed May 21, but the bill said that it would be effective 6 months after the signing of it. I put September, but it's November that it would be effective. September is our internal deadline for us to make sure that we have everything together and can get that information out to the industry so that everybody will have time to submit the applications in November. So then we have negative options and automatic renewals. This is S434, and it became effective on May 20th. It prohibits automatic renewals of certain consumer service contracts unless the consumer is given notice 30 to 60 days in advance of the renewal, and that notice tells the consumer that the contract is about to renew, how much is going to be charged upon renewal, and it has to give methods that the consumer can use to cancel it. And those methods have to include a toll-free telephone number, an email address, a snail mail address if they directly bill the consumer, or any other kind of easy to use mechanism that they can access for cancellation. And this only applies if the renewal will be for more than 1 month. And once the consumer renews, it'll make the contract be of a term that would be greater than 6 months. So it applies to consumer services, and there's also a component that applies to insurance, to certain insurance products, and the Department of Insurance is administering and enforcing that portion of it. It's in a different title. So we're working internally right now on getting some education out for businesses as well as consumers on this new law. So this one, online age verification, is something that's outside of our normal bubble or purview. So this is H3424. It became effective May 21st, and you can kind of see the history over here to the right. It was pre-filed in December of 2022, and it was another one of those ones that eked through on May 9th, the last day of session, so that it could become law. It requires entities that publish material that could be harmful to minors, which is essentially adult content on the web. They have to engage in age verification. And age verification methods can include digitized ID, they can use a third-party vendor, or any other commercially reasonable manner to ensure that the person who's accessing the website is 18 or older. Again, not a subject matter that we're used to. Title 37 generally deals with consumer credit, or the solicitation or marketing and purchase of consumer product goods and services. We had attempted to get it moved into Title 39 and out of Title 37 so that we wouldn't have any purview over it, but unfortunately it was successful. But then in the confusion of the last day, I think it just got back into Title 37. But Texas does have a similar law, as do some other states. And Texas was sued shortly thereafter their law passed, and it's made it all the way up to the U.S. Supreme Court, who has agreed to hear that case. And so I'm sure that there'll be more coming down from that in the near future, so we'll be following that closely. And then lastly, we have pre-need funeral contract penalties. This one just became effective on July 1st. And pre-need funeral contracts are those contracts where if you go to a funeral home and you want to go ahead and pick out the casket and your funeral, what your funeral would be, and pay those expenses before you need it. And a lot of people choose to do so to take that burden off of their family. And you have to have a license. Funeral homes have to have a license with our office if they are going to offer pre-need funeral contracts, because there's trust account provisions and lots of consumer protections in place to make sure that that money is still there whenever that consumer passes away and is ready to take advantage of the contract that they signed in advance. And so we always have a pre-need case open. Lots of times folks like to use that money that's taken up front instead of putting it in trust and using it for operational expenses, or they just choose not to get the license with us and don't otherwise comply with the provisions of the pre-need funeral contract law. So this particular law increases the criminal penalties for people that violate the pre-need funeral contract statute, and those penalties are based on the amount of money obtained or sought. So they go from a misdemeanor to a felony, and it just depends on if the amount of money is greater than a certain threshold on where it would fall, and then what that penalty would be. And the monetary penalties are mixed with some jail time as well at the discretion of the judge who hears the case. All right, so here is the Statehouse website again, and just want to point out a couple of things. So I mentioned earlier getting involved in the process, so you can certainly contact your legislator to do so. If you don't know who your legislator is, there's a little box right there in the bottom right-hand side that you can input some information. Or I'm sorry, you can, if you know who your legislator is, and then over on the left, it has find your legislators, where you can input your address and they'll tell you who your legislators are. And then I have the research button there that we talked about previously. Whenever they are in session, you can go to chamber video and check out the Senate and the House. You can either listen to it audio or you can watch the video. There's also these chamber dashboards in red that are underneath the Senate and the House of Representatives. That lets you choose what you want to watch. Do you want to watch the video? Do you want to watch the current amendment? Do you want to take a look at the journal? It's like a one-stop shop for all the different items that you may want to look at. The calendar for the day. You can watch the Senate and the House at the same time. It gets a little harried sometimes. We do that here at the office. You're looking at closed captioning on one and listening audibly to another, but you can. It's really great as far as transparency goes, and to be able to follow those items. And then you have the meeting schedules for both the Senate and the House that are over here as well. So you can see there are some upcoming meetings in August. And then over in this top right-hand corner, the mobile app for Android and iOS device services, if you go there and click on it, it can tell you how to download that onto your phone if you want to have the app. And it's really intuitive as far as going through and setting reminders for particular committees if you want to be notified when they meet, or bills, following bills and any changes to those. All right, so that's all we have for today. I'm going to see if we have any additional questions. Are pre-need contracts transferable to other states? So we would look to, I think in the past, from what I recall, is we look to the other state to see what their laws are. And if they have a pre-need contract law, which I think the majority of them do, you would be able to transfer it to a licensed pre-need contract or register, whatever the state requirement is, pre-need contract provider. And it's transferable within our state too. Like, just because even if you engage or sign a contract that is guaranteed and irrevocable, which is what a lot of people do, because you're locking in the price of the funeral at that point in time, you can transfer it to another pre-need licensed provider within the state of South Carolina as well. It just, the money will stay in the bank. It will not be released to the funeral home or to the consumer. It would just go from one pre-need provider's account to another pre-need provider's account, and the contract would physically transfer from one funeral home to the other funeral home. Good question. And I do believe, and Scott Cook, our communications director, is behind the scenes on this webinar. Scott, I know the investigators did a pre-need webinar earlier in the summer. Is that on our website?
I believe it's on our YouTube. I'll double check and see if I can find that link and pop it in there.
Perfect. Thank you. So Scott's going to check for that. The investigators, we try to do some topics on the areas that we directly regulate, do some webinars on those, and they just did that one on pre-need. I think it was in May, and so that could be helpful to answer any pre-need questions that y'all may have. So he'll look for that and hopefully get it over in the chat if we have that available. And we have lots of YouTube videos. If y'all have, if there's any subject matter or topic, our complaint process, or anything related to homeowners associations, or all that good stuff, we have a lot of content on our YouTube video, and there are playlists for different subject matter. So you can take a look at that and get to a video that could be helpful to answer any questions or otherwise educate you on our particular subject matter. Another question, follow-up question on that is about charging for the transfer. I think there's a 10%, like the transferring provider is allowed to keep 10% of a fee, but I don't know that offhand. We'd be happy to email you more information on that. I do know that there's an administrative fee that can be kept by the transferring funeral home, just not 100% sure on what the cap is. There is a cap in the law, but just not 100% sure on what that is. Let me make sure that nobody from our office is tuning in here that knows the answer to that question and didn't type it in for me. Yeah, we'll have to follow up with you with more information on that. Hope you have a wonderful rest of your day and stay cool. Thank you.